Your Lordship. I beg to mention item number 6, Your Lordship.
Item number
6. Maybe list this matter after 2 weeks, Your Lordship.
just wait for your turn. We'll consider your case. Wait for your turn.
Yes.
Item number 1 and 2.
May it be lordships.
Yes, Mr. Majumdar.
My lord, on the last occasion, your lordships were pleased to call for certain records with specific names of the file, etc. I am told, my lord, my learned friend has obtained some record, but one record possibly he is yet to obtain, subject to what my learned friend says.
So, Parme, we have all the records.
My lord.
Mr. Parme, when you will able to give that record? Others are available with you.
Yes, my lord. 4 out of 5 file, my lord. 4 is available, my lord. 1 we couldn't. We are tracing out, my lord. 4 with me, my lord.
Okay. Give us those records. We'll return it to you tomorrow. But let the other records also be there, the 5th file. 1940. We'll return with the records and you retain those records. So production the next day along with the 5th file. Okay.
Either you retain yourself or you can keep them back, but on the next day, all
We
the
have to
records.
produce it.
And let him retain. It's always better that he retains.
Unless department seeks back.
Let him retain, my lord.
Heard Mr. D. Majumdar and its senior counsel. appearing for assisted
Appellants. Pankaj Boram.
What about item 3? Is it also huh? Similar.
So this order will be for
I'm
120.
Take 1 minute.
Presented by Mr. R. Sekar, counsel appearing for the petitioner in writ appeal number 28 AP 2024. Would be matter.
Vegetable 35.
Also heard Mr. H. London counsel appearing for the petitioner in writ appeal number 1 of 2025. Heard Mr. D. Pangin, Land Council, L. Parmil, Landed Standing Council, Department of our Government of National Service for the official respondents, and Mr. D. Pangin, Land Council appearing for the writ petitioner CES respondents.
In readable, what am
In writ appeal 28 of 2024 and case 35. We are not appearing in 1 of 2000.
Item number 3.
One and two.
Item number 3 is the senior most among those.
Mr. Parmil, Landed Standing Council, Power Department of the State submitted that out of the 5 records, it was sought for by the court by order dated 30/04/2025. The department concerned provided him only with 4 records, and the record pertaining to file number PWRS/E-1995/2009 is yet to be traced out. Considering the same, list these matters once again on 19/05/2025. Mr. Parme shall retain the 4 records that were called for by order dated such and such, and shall produce in the next date. Further, 19/05/2025, the respondents in the power department shall also place the records of Friday PW
Bench position
list accordingly.
My lord, may I know this bench will be available on that day, my lord?
Why do you think that this bench should continue?
My lord, Lordship has given a specific date of. My lord,
Yes,
if
it doesn't matter. We may come back again. We have not yet received
No,
the
what I am submitting, my lord, if this bench is sitting and according to your lordships have fixed, I have got no difficulty. Otherwise, could I pray for 15th, my lord? 15th, I have got one small matter there. So if I go there, I'll be physically present, my lord. 15th, my lord, I'll be,
15th.
my lord, that is the
Fine, no
reason.
problem. On 15th.
Otherwise,
Mr. Parmil?
my lord, lordship may not take it. Otherwise, if your lordships are sitting on 19th, lordship
No,
may
doesn't
very
matter.
well fix it
On
on
15th.
19th.
We don't have it. Do not. Okay. Okay.
Because
We'll have it on
roster
15th.
is not yet available for that next week onwards.
You might know, we don't know.
No, madam, it has not been published. Today, Friday, it will be published. Madam, what I am saying is, madam, I wanted to pray for making the matter part-heard.
Mr. Madhura, since you'll be here on 15th, let it be on 15th.
Madam, deeply obliged.
Mr. Parmil, for the time being, we'll go to the records and find it. Okay.
Obliged.
Please, ma'am. So, my lord, in this case, on the last occasion, my lord, the last chance was given to, granted to the respondent number 4, 3, and 6 to file their counter affidavit, which was supposed to file on or before 5.
And whether they have filed or not, my lord, I have not received so far. ma'am.
Yes.
May I please, Lordship? Lordship, yesterday evening, we have received instruction from the department, Lordship, and Lordship, we are about to file today, Lordship.
Okay.
So, Lordship, there is some,
Let us see your instructions.
Lordship, there are some pages which is need to be rearranged, Lordship.
What's your good name?
Ketabang, Lordship, on behalf of Tijamo, Lordship. And Mr. Tijamo, he is out of station, Lordship.
Mr. Such and such. On behalf of Mr. T. Jamu, Land Council appearing for the Inter-departmental Municipal Corporation. Submitted. He has submitted that he has received the relevant reports and also prepared the affidavit for the respondent numbers 3, 4, and 6. And the same is yet to be vetted. To that extent, Mr. Sansas have also placed the relevant instructions of the Itanagar Municipal Corporation as well as the copy of the affidavit that has been prepared for the said respondents. Considering the same, the respondent numbers 3, 4, and 6 are directed to file their affidavit in another on or before 13/05/2025, reserving copies of their affidavit to the council for the petitioner and other respondents, failing which this writ petition shall proceed expert against those 3 respondents. Take back and file it.
Deeply on Lordship.
List on 14th of May.
My lord, in this case, while during the proceeding of the case, my lord, on 24/5/2024, this honorable court has passed a specific order whereby the respondent was directed to file a additional affidavit. Now I have received the additional affidavit filed by
We asked for certain records.
my lord. So additional affidavit issue with me and I have received, but
The whole proceeding, Lordship, has been, I have filed it additional affidavit, the whole proceeding, Lordship.
But we have asked for the relevant records in original,
Lordship,
the last order. We have seen that as because the person is very powerful, being wife of somebody. So we wanted to see the records. How it is progressing. When we missed it.
Lordship,
Okay. Produce it next date.
Lordship,
On the prayer of MSC,
Lordship,
London Edition, Sitting Government Advocate Arunachal Pradesh. Matter be listed.
day after, Lordship.
On 8th of May. Enabling her to place the relevant records of the chief estate officer that was called for by order dated 28/04/2022.
Otherwise, Lordship, as per original order, Lordship, para
We have
10
the-
and 16.
Let us have the record.
Lordship,
How it progressed.
understood, Lordship. of lights.
My lord, I am for a petitioner here, but despite that I am the petitioner, but due to paucity of the time, my lord, I could not go through the record in the last night since I was out of the station. Therefore, my lord, this adjournment has been short for. So, my lord, my prayer is that my lord list, can this matter be list, my lord, after 1 week, my lord?
On the prayer,
Repass or Hachin repass? Class 12 or BA?
My lord.
Otherwise, my lord, she has already been promoted also, my lord.
okay,
Only seniority can be, my lord, decided.
but she was not considered in that DPC. But one thing is very particular is there. The circulation, you have received the relevant information, but in spite of that, you have not submitted the relevant
Correct.
records.
My lord.
Law is well settled. There is no difference in this because we are telling you there are judgments in that regard. If you insist on this appeal outcome, it's very clear. It is what we have seen from the records. It was circulated to you. You are supposed to submit your ACS. You are supposed to submit your all details, education and qualifications. So we have not done. And in that regard, there are judgments of our High Court.
And if you have submitted subsequently, sir, that you have been promoted, what remains in the.
My lord, I have to answer, my lord, to the next.
But outcome, we have made it clear. There are judgments of our High Court. There are judgments of the Supreme Court, but considering those judgments of the Honorable Apex Court, our High Court has passed judgments. Find out. Even Mr.
How
Kato.
the PC will consider your case in absence of documents if you are supposed to. do.
My lord.
It is not that the respondent authorities will give it before. It is supposed to, you should produce it.
Yeah.
Anyway,
Well,
on the prayer of Mr. Simon, counsel for the appellant, matter be listed after 2 weeks and it have to be fixed by the district. Okay.
deeply.
But in the paper book,
Yes, Your Lordship, I deeply apologize, Your Lordship.
in the
The,
paper book, what we found, the entire report of the postmortem report is not there.
And
Some
also
portions are
the
missing.
forwarding of those exhibits, my lord, the samples are not mentioned. Though I have enclosed in the main appeal, but it is not mentioned in the,
We have
paper book.
cross-checked with the original records, what we found in the postmortem report, in the paper book,
yes, Your Lordship.
the portion is missing.
That can, the register may be directed to annex the same in the paper book, otherwise, Your Lordship.
otherwise, my lord, this whole case is rests upon a circumstantial evidence, my lord. And there's not even a single inculpatory statement by the prosecution witness or the co-accused, my lord, implicating the commission of offense in respect of the appellant, my lord.
When there is no eyewitness will implicate.
My lord. Solely, they were, in fact, my lord, two DNA reports, my lord.
Apa itu bisa? Aku ya kamu ini pemberatan. Ano para? Tapos matang dito ka. Evidence ka ka man paper book. Yan it na lang.
Bail and the image.
Ah. ¿Dónde la Ma, akan eh.
During the deliberation of the matter. And on perusal of the records, it is seen that in the paper book, the postmortem report of the deceased is not complete. Yes, next, what you have said?
My lord, the date of forwarding of the first sample and the second sample, it's in page number 106 of my petition, my lord. 106, forwarding of the samples, my lord. Dated 6/9/2012.
Is it required for adjudication?
Since, my lord, that is very much relevant in this case, my lord. We are
Already-
questioning. Otherwise, it's all right, my lord. I'll rely on the petition, my lord.
Okay, that doesn't matter. Okay. Registration. Do the necessary correction in the paper book of the case after due verification from the exhibit file in original. On the series. If you had a part of it, but it is what it is.
There was also in one IA, my lord, I was pressing for consideration of
Not
bail
at
and
this
suspension
stage.
of sentence, my lord.
You are aware what is there
My lord.
in the evidence? Just like a hard. You are Mr.
J. Sring, my lord.
J. String, counsel appearing for the appellant. You are a public prosecutor. Put her name. You are appearing for Ginny. What's your good name? JD. All right. Learned counsel. Legal aid counsel. Appearing for the informant. Respondent informant number 2.
Grateful.
Who is appearing for Public Service Commission?
Lordship,
Now, what happened with that particular officer who was arrested? What is the stage of the investigation against him?
charge sheet has been filed, I think. Charge sheet has been filed,
Charge sheet has been filed.
but that is related to another matter. It's not related to this.
Not related to this selection.
Yes, madam.
The person was arrested in connection with a different. process.
Examination process, madam.
Not, he is not in the charge sheet that is in file.
Yes, madam.
Take your seats.
Selected candidate right away. Here, selection is coming. This is very
Who is appearing for the petitioner?
Yes, madam. I'm for,
Have you gone through the judgments?
my lord.
Have you gone through the judgments?
So, yes, madam. Who is under challenge?
Not the judgment rule, Anand Singh Judge. Judgments of our High Court or the Honorable Apex Court in this regard.
See,
My lord.
two aspects of this paper. Selection process. Suppose you are selected.
My lord.
At that stage also, employer has a right to cancel that selection.
That is one. That is one sitting.
The court can interfere only in a case whether such decision is arbitrary.
Mal.
Okay? In your case, the selection is not even concluded. It was midway cancelled.
Yes, ma'am.
And they have some reason. They have cited some reason. It is not that there is no reason. Now, therefore, the question remains whether such action of cancelling the selection is arbitrary.
Mal.
There is nothing in the judgment.
You could not place anything to that
anything
extent.
to that extent that this is arbitrary. They have some reason. They want to keep the public image perfect of an institution like Public Service Commission.
Mal.
So you know the object of the constitutional provision of Public Service Commission, so that it's clean and clear. Now they think that this person who was the hand of the affairs is himself is arrested, so it will send a wrong message. So therefore, since selection is not completed, we will cancel it and have affairs. Where is the arbitrariness?
Mal,
And where is the finding in the judgment that this is arbitrary for this reason?
Mal,
Only because you don't have any right of selection. You don't have even any right of appointment even after selection. In that context, what will be your right to get the selection process continued?
yes, ma'am.
That is very minimal right, and that can only be interfered with when there is an arbitrariness. Nothing is there in the judgment.
Malo, before coming to that, Malo. Malo,
See, at
yes,
this
ma'am.
moment, we are not hearing you. We are just pointing out.
Yes, sir, yes,
pointing
ma'am.
out
I'm
these
getting-
queries to you.
Yes, Malo.
In this regard, you will have numbers of judgments from our High Court
Yes,
as well as
All over.
appeal by the division
Satisfy
court,
that
as
only.
well as the apex.
Malo,
Satisfied.
Malo, while cancelling this, Malo, the examination process, Malo, in the midway, Malo, it's gone up to the written examination. Then Viva has been, Malo, cancelled, Malo. Malo, it is true, Malo, for administrative reason. Malo, it can be, Malo.
No,
Okay.
no, you are making this is the mistake. They will have to give reason, but it should not be in the touchstone of Article 14 and 16.
Yes, ma'am.
It should be in the touchstone of arbitrariness.
Yes, ma'am.
You don't have any right under Article 16 that the selection should be completed. You have a right that selection should not be completed for as a result of arbitrariness. And arbitrariness definition in the context of selection process has been defined in many judgments in the
In fact, I had done same thing. There was a council,
Yes, ma'am.
higher secondary council, there was a filling up a post was there. Initially, as a single judge, I passed the judgment, directing the council to complete the process. Declaring the result. The matter went up to the division bench.
Ma'am.
Then division bench decided something and sent back the matter to the learned single judge again for consideration around that particular periphery. Then I've changed the decision.
Malo,
That is why I'm pointing it out. Secondly,
yes, ma'am.
there is a doubt on the part of the FCA because many have passed the skill test, but only 2 have been selected in the written test. And the person concerned who was arrested because of leaking of question papers, and he was the helm of the affairs.
Malo, in
That's
this case,
how-
Malo,
That is what you have, that is in their affidavit. So it will be your duty to support the judgment.
yes, Malo.
Right, there is, when both of us have read the judgment of the learned single judge, there is no arbitrariness, there is no question of any arbitrariness, because the affidavit is very clear.
It is proceeded as if you have a right to continue for selection.
You cannot have.
You don't have any right.
Malo,
That is for sure.
in the context of facts and circumstances in my case, Malo, Malo, there was 21 forced, Malo. Out,
Whatsoever.
Yes, my lord.
See, foundation is something different.
yes, Malo.
Maybe, yeah, they might have decided to, tomorrow then, no, we will not proceed, now we will not fill up this post.
Malo, but
No, we are having financial constraint, we are not filling up this post, so cancel the selection process.
Then
but for that,
Then-
Malo, there must be some reason, Malo, justifiable reason, Malo.
Justifiable reason
Yes,
is that there is a serious doubt on the sanctity of the selection process.
Yes,
therefore is sufficient.
And in Supreme Court says there, even there is no inquiry is required,
Right.
if they have prima facie satisfaction as regards sanctity of the selection, they can cancel the selection.
Malo, that, Malo, from my satisfaction has not been done by the public service before, Malo, cancelling
Where
this
is the
exam.
discussion?
My lord,
Where
in
is the
their,
discussion in the judgment?
my lord, in their affidavit, my lord, they have taken only two stand, my lord.
According to us, these are grounds on which the APSC can cancel a selection process. In that context, you don't have a right to get the selection continued.
But, my lord,
There's something.
Yes, my lord. I
action
understand
must be relatable to your right
yes, my
and
lord.
their duty.
See, we are not,
Yes, my lord.
you have to show the judgments, otherwise,
My lord,
They
may I
are-
place-
We are otherwise we can accept the judgment,
right?
taking our view.
We are asking you to go through the judgments of the apex court and our high court in that regard.
You are still going, want to argue this case today?
my lord, my lord,
You want to argue this case today? Please tell us.
my lord, sir, may I place
Are
one,
you
one
ready to
judgment? my lord?
convince, you see, we are not, we are always open to ideas and
Yes, ma'am.
decisions. No quarrel about that.
My lord.
But we have, both of us have had something in mind, we have also read. If you want still to pursue, you can very well try to pursue, but you must have those judgments. I can give you those judgments in 3 minutes against you.
My lord,
You want to proceed?
can I
No,
place
please
this one?
tell us, we'll
Yes, ma'am.
proceed, no problem. If
Yes,
you
ma'am.
want to, argue this case today,
My lord,
So go
I'm
through
ready.
the judgment, cross-check.
I'm ready, my lord. I'm ready. Because, my lord, this is, my lord, regarding, my lord. Oh, my lord, yes, if some other date is for your lawsuit convenience, my lord, but I am ready to tell you. Because, my lord, this is a case of, my lord,
Yes, I will.
May I, Your Lordship? Lordship, as Your Lordship has rightly pointed out that in the entire judgment, impugned judgment and order, the learned single judge has not addressed any a violation of fundamental rights, Your Lordship. And the cancellation of the exam was done because the person who was arrested was the controller of examination.
The record with you, which is relatable to that decision. You have filed an affidavit,
Yes, Your Lordship.
but this is a writ of certiorari.
Yes, Your Lordship.
To set aside your decision to cancel. Writ of certiorari is a certification of record by a high court. You have that record so far relating to the decision that in this circumstance, you have taken in affidavit, but there must be some office note, how it proceeded.
Your Lordship, there was a representation submitted by stenographer associations unemployed. Although we have not annexed that.
That's why I
representation.
want to say, you have disclosed certain things in the affidavit, saying
Lordship.
that this is the reason. But we want to see the actual reason and how it proceeded, how it was initiated. Are you having the record?
That representation, we don't have it right now, Your
Not the
Lordship.
not the
The
representation.
decision.
Where is that order?
Concern-
Impugned
Order is in page number,
You produced a record of the affluent Arunachal Pradesh Public Service Commission on the next date. So I'll place the following records in original. PSC, small Roman only. PSC, dash R, within bracket capital A, oblique 05, in which the appellant PSC passed a order dated 30/09/2022 by the order number PSC dash R within bracket capital A, oblique 05, oblique 2022, cancelling the entire recruitment examination process of SPA. Yes, Sunil, put this record, tell us.
next week, Your Lordship.
Sixteenth?
Lordship.
On 16th. There are Many judgments in favor of the Public Service Commission.
Lordship.
One place it.
And apart from this examination also, another 3 to 4 examinations were cancelled,
No, that
already
doesn't
conducted
matter.
examinations.
But with regard to the SPS, so
Yes,
why
Your
you have
Lordship.
taken that decision? Yes, ma'am.
See, that decision is, we'll have to have a satisfaction, that decision to cancel is arbitrary. That's all. If it is arbitrary, he is in, if it is not arbitrary, he is out.
Obliged.
And you know what is the arbitrariness, and arbitrariness is to be taken in the context of the right of the person who says it is arbitrary. What is his right and what is your duty? In that context, arbitrariness is to be decided in the present.
Right, ma'am.
Obliged.
May I please, Your Lordship, I beg to mention item number 9, Your Lordship. Item number 9, Your Lordship. In this, Your Lordship, I'm making this mention on behalf of Mr. S. Kapil, Your Lordship. He is out of station. Your Lordship, this item may be fixed after a week, Your Lordship. After the week, no.
Lordship, recovery matter, Lordships, excess payments, Lordship,
Hmm,
recovery, Lordship.
it has been stayed.
Judgment say, Lordship, if retire, employees retire, Lordship, recovery will not be possible. not
Recovery was
permissible.
stayed.
Yes, Lordship.
There is an interim order.
No, there is no any interim order, Lordship, in this case, Lordship. So that, Lordship, therefore, Lordship, we need earlier date, Lordship. Next week, Lordship.
Your Lordship, I have an instruction that, yeah.
See the last paragraph.
Oh, Lordship, yes, Lordship, sorry, Lordship. Lordship, interim is there, but
Don't assert
Lordship,
first. Be sure, then you assert.
yes, Lordship. Lordship, interim is there, even though Lordship, here, Lordship, on the basis of this order, Lordship, the pension of the
Notice in
petitioner,
this case was issued
Lordship. Pension, Lordship, pension in case, Lordship, pension is also not issued, Lordship.
04092024. File your application that pension has not been paid. We'll
No,
consider.
already pension matter is also pending here, Lordship.
In another repetition?
Yes, Lordship.
What is that?
Lordship, I will give you a number.
Give us the number.
Yes, I'll provide, Lordship, number of the petitions.
By the order dated 04092024. The recovery of rupees 4,33,138. From the leave salary of the petitioner has also been stayed. However, the respondents in the public and health engineering and water supply department and other state respondents have not yet filed their affidavits.
Your Lordship, we have filed already, Your Lordship.
You have filed?
Yes, Your Lordship.
When? Which department has filed? Finance and accounts.
Yes, Your Lordship, for respondent number 2 and 4, Your Lordship. Others, they will not file, Your Lordship.
They accept the respondent numbers 2 and 4, finance and accounts. Comma, and Director of Audit and Pension. The other respondents shall file their affidavits without fail on or before 19th of May, placed on 21st of May. Failure on the part of the other respondents to file their affidavit on or before 19/05/2025. This writ petition shall proceed expertly against those respondents. Give us the number, list along with.
Okay, Lordship.
uh,
I will give the number.
List along with such and such.
Much amount.
Your Lordship, I have another mention, Your Lordship. Item number 15, Your Lordship. Item number 15. In this, Your Lordship, we were required to bring on record, Your Lordship, but we have not received yet, Your Lordship.
Pursuant to the order, notice in this case was issued on 25/02/2025. And the Forest Department of the state respondent numbers 1 and 2 are yet to file their affidavits. By order dated 29/04/2025, the court directed to place the relevant records in original relating to the order dated what was the order passed on 28th of January? Any idea?
Sir, Your Lordship, notice was issued on 28/1/2025. And as per this order, Your Lordship, the ensuing prayer shall be considered on the next date fixed.
Pursuant to the such and such. The respondents of the Forest Department of the state shall place the record of FOR.37/EA/2022-25, wherein the impugned order dated 21/02/2025 was passed. Placed on 16th of May.
Obliged.
Copy of this order to for necessary.
May I please, my lord? I beg to mention item number 16, my lord. We are
16,
my lord.
yes.
We are appearing for the first time. I've taken the consent from the Council of Union of India. We are for the
What's
private
your good name?
HK Jamo, my lord.
You are appearing for whom?
Private party. This is an IA for condonation of delay. So we will be filing our objection.
Heard Mr. M. Katur, Lanet, DYSGI for the applicants. Also heard Mr. H.K. Jamus, Granite Council, appearing for the opposite party number. Both 1 and 2,
Yes.
numbers 1 and 2. List on 28th of May. In the meanwhile, the the opposite parties 1 and 2 may file their objection, if any, on or before 16th of May.
My development. My lordship, I would like to mention item number 7. My lordship, the leading counsel, due to some severe health problem, he could not attend the court today.
What's your good name?
Here on behalf of HK Das.
Even in last occasion, I think so matter was adjourned in the prayer of Mr. H.K. Das. Yes. Adjournment has been sought for on behalf of Mr. H.K. Das and outstation counsel who appears for the petitioners in this matter. Even in last occasion, IM 0205-2025, similar prayer was made and the court accordingly granted time and fixed the matter today. List on 16th of May.
My lord, can it be on 28?
My lordship.
Same matter has been listed on 28.
200.
28.
On the prayer of the council for the parties, list on 2805 as connected matters are fixed on the same date. Okay.
Obliged.
Much obliged.
May I please, your lordship, item number 12, your lordship. Here the state has already filed their affidavit. So in response to that, I have to file affidavit in reply, your lordship.
Just a
But,
minute.
I could not reach out to the client. I don't know whether he want to proceed with the case or not. So further, at least 4 weeks time may be granted so that I enabling me to take instruction. Regarding filing of affidavit in opposition, I have already communicated.
Heard Mr. A.K. Singh, counsel appearing for the petitioner and MSG at Learned Additional Senior Government Advocate appearing for the respondent numbers
Is that respondent?
1, 2, 4, and 6.
Yes.
Notice in this case was issued on 20-01-2023. And the respondents in the PWD in bracket response number 3 have filed their affidavit. We are back on 29-06-2023. So serving a copy of the same on the counsel for the petitioner. The petitioner is yet to file rejoinder to the same. Issue rule as the respondents have already appeared in this matter. No formal notice need to be issued. List this matter for hearing on 17th, just a minute. Okay, 10th of June. In the meanwhile, the petitioner may file rejoinder to the affidavit of the respondent number 3, if so advised without fail.
My lord. My lord, I beg to mention item number 8. I'm appearing for respondent number 5. Here, we need to file an affidavit in opposition.
The last opportunity was given to that to file the reply. For the petitioner.
Yes, Mr. Lord. Heard Mr. D.K. Dury, Learned Counsel appearing for the petitioner. And Mr. Aris Namam, Learned Additional Advocate General, owners of this, for the respondent numbers 1 to 4. Also heard, what's your good name?
Punyo Harming, respondent number 5.
Learned Counsel appearing for the respondent number 5. Notice in this case was issued on 06-06-2024. The official respondents have already filed their affidavit on 18-09-2024. Serving a copy of the counsel for the petitioner. Though the respondent number 5 has entered appearance in this matter on 10-09-2024 by filing occurred number, yet to file. He is yet to file the affidavit. Issue rule as the parties to this proceeding has already entered appearance. Respondents have already appearance. No formal notice need to be issued. List this matter for hearing on 11th of June. In the meanwhile, the respondent number 5 may file its affidavit on or before. Okay, not on 15th. June we are fixing it for June 6. Okay, 11-6. In the meanwhile, the respondent number 5 may file its affidavit on or before 22-05-2025. Serving a copy of the same in the counsel for the petitioner. Thereafter, the petitioner may file rejoinder to the affidavit of the state respondents as well as the respondent number 5. No further time shall be granted. to either of the parties, respondent number 5 as well as the petitioner, to file their affidavit and rejoin this as directed above. List accordingly.
Writing the audience of my lord.
Yes,
I-
Mr. Tara.
My lord, I am extremely sorry. There are 9 matters today I have, and this matter I could not lay my
Which one?
hand.
Which one?
Item 6, my lord. My
Doesn't
brother
matter.
is so kind to accommodate me
When do you want?
on 19th. my lord.
On 19th? Just a minute. We'll consider.
Alia.
Okay. Heard Mr. Director, and counsel appearing for the petitioner. And Mr. N. Father. Learned counsel. You are appearing for which respondent? 3 and 4.
I'm for 2.
Also heard MS Puthan, Learned Government Advocate for the respondent numbers 1 and 2. Notice in this case was issued on 07092022. An interim order is in force since then. Considering it, list this matter. On the prayer of Mr. Tara, learned counsel appearing for the petitioner. List on 15th.
My
19th.
brother is not available.
On 19th, you want Mr. Tara will be available? Okay, on 19th. No,
Mother, interim to continue till then.
I think it is until there is specific order.
Yes.
It is, shall not be given effect without taking view of this court. So not required.
I am ready.
Okay. Yes, Mr. Kato.
My lord, I'm sorry, my lord, yesterday
Doesn't
I,
matter, doesn't matter. Since we are in a single bench, we are not on the other side. We'll be issuing notice in the contempt only.
Right.
But what we have seen, there is a specific admission on the part of the petitioner in that regard. But anyway,
and I'm told, my lord, the appeal is also pending, my lord.
appeal is pending.
Appeal against this order, my lord, has been prepared by the Union of India through other council, my lord.
Okay. It's pending.
Yes, ma'am.
Doesn't matter. Do you have the number with you?
Yes, my lord. It is WA number 18 of 2020.
18 of 25.
Any stay?
No, I'm not, no stay, no stay.
Okay. Hard. We'll just issue notice in this. But Mr. Kato, there is specific judgment, RL Jain versus State of versus DDA, Delhi Development Authority. It's very clear.
Your Lordship, recent judgment?
It's an old judgment relating to old act, where in such circumstances, when somebody takes a possession of the land and the land acquisition proceeding lapse,
Yes.
the court can, even the collector can give the award to the continuing on the rent. In fact, I can tell you.
Yes,
there was a
yes, I
judgment-
remember that.
There was a judgment passed by Honorable Justice in a division bench, 2 judge bench in the Supreme Court, was consisting of Justice H.K. Sama. Then thereafter, there was another judgment prior to that passed by Honorable 3 judges bench. So it was brought to the notice of that particular bench. They did not review it. So in a larger bench, the same bench, if another judge considered these aspects, and in that judgment, it has been clearly discussed each and every issues. What happens? Subsequent judgment, you will see where the Honorable Apex Court have clearly mentioned that in which cases and when the interest component can be given
Yes.
by the collector.
Yes.
Though it is very specific that the interest components may come when the collector of the when passing the award, or maybe in the appeal before by the High Court, or before the any appeal against the order of the High Court pending order passed by the Honorable Supreme Court. But when these cases comes, it is very specific that only the rent is payable because the acquisition proceeding starts only from the date of notification.
Yes, yes.
If it lapses, it lapses.
Mm.
There cannot be a question. But in a case, what happens when the award has been passed? Compensation amount has also been deposited. Maybe there is a reference case, apportionment of compensation, or regarding to the amount of land is less or it is more, and there is a stay. In that circumstances, even if it is the award could not be fulfilled because the money could not be, the compensation amount could not be disbursed. In that circumstances, it will not lapse. There are many cases. So here is a case relating to Delhi Development Authority. In fact, you will get a case, a recent case, where the Honorable Apex Court has interfered. It is, the Ralsana Hill, enter the secretariat, enter the thing of the new
Yes,
Delhi
yes,
is there.
yes.
Somebody long back, the land was acquired without paying any compensation. There also, their losses have interfered. I think that case has not been reported, but I read somewhere, considering this particular judgment. So only the rent is payable. And when the collector passes any award or collector passes any order pertaining to the rent, if it is not deposited within the time limit, then only the court can pass an order for interest and not otherwise.
Mhm.
So these things have been already settled by the Apex Court.
Mhm.
Because normally we don't go to that extent, but in some cases, whenever you required, you go through. But that is the law. You can go to the decision of
I was not
Jain
aware of
versus
that.
DDA. No, definitely, it's
Yeah.
an old judgment where they
Yes.
have three judges benches considered.
Yes,
RL Jain versus Delhi Development Authority. You go through that. They have discussed all these cases.
yes.
Contempt is to clear. Hard MS and then Land Council appearing for the petitioner. Matter relates to willful disobedience and non-compliance of the order dated
14/5/24.
14/05/2024, passed by a single judge in WPC number 97, which is indicated KB object 2021. Issue notice returnable by 6 weeks. Petitioners shall take steps for service of notice on the response numbers 1 to 8 by registered post of reading on or before 14th of May. List accordingly after 6 weeks on the date to be fixed by the registry.
All right.
No problem. You just different. Segregate the records of WPC number 97, PP 2021, decided on. Fourteen 05/2021. God, Mr. D.K. Devi, counsel appearing for the petition. Item Article 4 contain 4 Arunachal Pradesh Code. Arunachal Pradesh Code, sorry, number 3.
Lordship, I have received the instructions.
You have received the instruction?
Yes.
Yes, that will be required. Hmm? Hmm. Yes. Heard Mr. D.K. Dury, Council appearing for the petition. And Miss
Arbasar.
Lund, Government Advocate on Andhra Pradesh, appearing for the respondent numbers
1, 2, and 3.
1, 2, and 3. The Superintendent of Police, Tirap District, Khunsa, white number TAPP oblique ESTT dash 14/2023 2251 dated 21/03/2025 issued eviction notice to the petitioners under section 4 of the Arunachal Pradesh public premises within bracket eviction of unauthorized occupants bracket close Act 2023. Directing them to vacate the police land under their occupation within 30 days of receipt of the said notice. And to submit the vacation report before the said authority. But the said eviction notice dated 21/03/2025, the SP Tirap District, Khunsa shall also clarify that non-compliance and oblique or failing to comply with the said notice, legal action shall be initiated against them. Full stop. Agreed the said eviction notice. The petitioners have preferred this writ petition, stating that the Superintendent of Police, Tirap District, Khunsa, is not the state officer as provided under the Arunachal Pradesh public premises within bracket eviction of unauthorized occupants bracket close Act 2003. Hence this writ petition setting it such and such. Pursuant to the order dated 22/04/2025, may such and such land government advocate have placed under 11 instructions. Listen, give it to us. Earlier, the petitioners preferred a writ petition being WPC number 81 within bracket AP oblique 2015 against a similar eviction notice issued under Arunachal Pradesh Census Public Premises Act for the same land issued by the Superintendent of Police, Tirap District, Khunsa, by the order dated 13/02/2025 under memo number TAPP oblique ZEN dash 11/2005 2014 PT dash 1. However, the court by order dated 17/06/2015 disposed of say WPC number 81 AP oblique 2015 preferred by the petitioners. Finding the said eviction notice dated 13/02/2015 issued by the Superintendent of Police, Tirap, Khunsa, the Tirap District, Khunsa was without any authority and the said eviction notice 13/02/2015 was not issued as per the provisions of say 2003 Act. since at that point of time, the Superintendent of Police, Tirap District, Khunsa, was not empowered to issue such eviction notice under the say 2003 Act, as the Superintendent of Police of Tirap District was not made or was authorized as an state officer under the say 2003 Act. From the records placed before the court by Ms. Such and Such, it is seen that the now, in the said order, dated 17/06/2015, while disposing of WPC number 81 AP 2015, the court also observed, the court also granted liberty to the state respondents to evict any unauthorized occupants from the land of Dimoli Police Station, public government premises, including the petitioners therein, if they are found to be in possession of any government land, public premises, by following the due process of law as envisaged under the provisions of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants Act 2003. From the records placed by Ms. Such and Such, Government Advocate Arunachal Pradesh, it is seen that earlier by order number LM-101, MO number LM LR लिखिएगा. That's 101/87 within bracket volume. That's capital Roman 2. PT dated 14/12/2009. Issued by the Commissioner within bracket Land Management bracket close Government of Arunachal Pradesh, allowed empowered AIGP, Police Headquarters, Itanagar, as state officer in respect of land and premises in occupation of the police department all over the state, with immediate effect until further order under the provision of Section 3 of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act 2003. Subsequent to that, the Chief Secretary, Government of Arunachal Pradesh, by notification number LR-101/87 within bracket volume capital Roman 2 bracket close /442 dated 30/06/2016. As provided under Section 3 of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants Act 2003, appointed all superintendent of police, commandants of AAPBN and IRBN, principal PTC as state officers for protection of departmental premises, public land, public assets under occupation, public possession of the police department, Government of Arunachal Pradesh, in their respective jurisdiction. Said notification dated 30/06/2016 of the Chief Secretary, Government of Arunachal Pradesh, was published in the Arunachal Pradesh Gazette Extraordinary on 18/10/2016. As such, the Superintendent of Police, Tirap District, Khunsa, is empowered to issue notice under Section 4 of the Arunachal Pradesh Provisional Public Process and such to any such unauthorized occupants for their eviction from the land of police department of the respective district within their jurisdiction. Considering this, the eviction notice number, impugn eviction notice of such and such and such and such, dated such and such, issued by the Superintendent of Police, issued by the such and such to the petitioners, is in compliance of the provisions of the Procedural 2003 Act.
No, this is not in compliance, at least. So,
Is as such, the impugn eviction notice of the such and such doesn't call for any interference. Needless to say, the petitioners may will their rights as provided under the said such and such act. This stands to this board of.
Your Honor,
While retaining certain this instruction for time being. Will be
Your
clear to me.
Honor say yes, section 4 says witness notice should be issued, but here.
You know what is there? Once notice has been issued, you are supposed to file your reply. You do that, whatever, will not
That
interfere.
liberty may be.
We cannot give him liberty, first of all. That is why we have said you may approach the affidavit authority under the said provision. See, basically, any action order, you are supposed to prepare an appeal, any order against the state officer.
But they had.
Right.
Yes.
It's a notice under section 4. You have approached this court because you are saying that the Superintendent of Police, Tirap district, has no such, he is not empowered to issue that notice. Now the notification is
No,
there.
no, not even, despite that empowerment, he should have issued so.
Even if it is wrong, you can approach the authority. First, you file your objection before the concerned authority. Whatever, will not interfere in the writ petition. That's the law. Yeah, I'll be requiring a copy of this. This is fully. Yes, Mr. Parveen.
Yes, and here, my lord, the petitioner, my lord, is having some serious concern against, my lord, conduct of the and misusing authority by the private.
I think, Ms. Sethi, you can, the matter is pending before the authority. Hearing is already, this appointment of a Gaambura who illegally has done something. The matter was already heard. Just let us know what is the status of that. It was heard way back on 4th of July. The Deputy Commissioner Likabali, Lower Siang District, heard the objection of the petitioners. Only the order is awaited. So let us know the status of that order from the Deputy Commissioner. That much at this stage, we will not interfere. When can you give it to us? Tell us.
This is with regard to private respondent number 3, no, Lordship?
Against that private respondent number 3.
Yes, yes.
He is the Gaambura and he has passed some, acted some illegally. So only that thing against that objections has been filed. And the Deputy Commissioner heard the matter. His order is awaited. That much only. If you want to give us the status, we'll cite, or otherwise, in the next day, we can dispose it of. That's all.
Lordship. I'll Lordship call for status of the case.
Because the Deputy Commissioner heard the matter on 4th of July. The grievances of the present petitioners.
Lordship.
Only the order is awaited. Whether he has passed any order. If you can tell us the order has been passed, fine. If he has not passed, only will dispose it of directing him at the earliest to dispose of the representation of the petitioner after hearing the issue. They have already heard.
Lordship.
The order is awaited.
Lordship. This I have seen.
Can you tell us by tomorrow, day after? Only by phone inquiry you can do.
Yeah, that was.
Only by over phone when. Otherwise, we'll dispose it off as soon as you give us the information. We'll not keep this matter pending.
Day after, Lordship.
Day after tomorrow? Okay.
Day after tomorrow.
Okay. On the prayer of MSD Attila and Government Advocate. List this matter on enabling her as to whether the Deputy Commissioner Likabali, Lower Siang District, dispose of the representation of the petitioners that he heard on 0407-2024. That much only.
Obliged.
But the predicament of the petitioner is that there was an advertisement for
loan availing under Deen Dayal Upadhyaya Sambalan scheme. She was selected, my lord, but in the impugn recommendation, her name did not figure, my lord. Hence the challenge, my lord. And the third part, the private respondent number 8, my lord, has been recommended instead, my lord. My lord, we'll
Long
see.
back.
Advertisement.
Heard Mr. T.T. Terrell, learned counsel appearing for the petitioner. You are appearing for,
1 to 4, my lord.
put her name. Learned government advocate for the respondent numbers 1 and 4.
No, 1, 2, 3, and 4.
1, 2, 4. The contention of the petitioner herein is that without considering her better claim, the respondent authorities in the State Bank of India considered the claim of the respondent number 8 under the Deen Dayal Upadhyaya Swavalamban Yojana 2024-2025 for eco-tourism homestay where the petitioner was a selected candidate and the respondent number 8 was a waitlist candidate. In the selection process initiated by advertisement number KKD/PLZ/DDUSY-220/2021-22 within bracket PT-1 bracket close -542-3 dated 27/09/2024 issued by the Deputy Commissioner, Kurungkome District, Kolariang, Arunachal Pradesh. Issue notice returnable by Hmm. 27th of May. As Ms. Hassan has accepted notice on behalf of respondent number 1 to 4, no formal notice need to be issued. Petitioner shall serve requisite extra copies to Ms. Hassan on or before 0805-2025, obtaining necessary acknowledgement from her in that regard. The petitioner shall take steps for service of notice respondent numbers 5 to 8 by registered post with hearing, providing their correct addresses with requisite postal stamps on or before same date. In addition to the above, paragraph was in, right? In addition to the petitioner is also allowed to take steps on the respondent numbers 4, 5, 6, 7, and 8 by dusty of the personnel service to be routed to the registry of this court. The petitioner shall take such dusty oblique personnel service on the respondent numbers 4 to 8 by serving copies of this writ petition, including the annexes appended thereto, obtaining their signatures
But
full.
R4 is represented by.
Sorry, 5 to 8, 5 to 8, not 4, 5 to 8. Full signatures with date and seal in presence of one or more witnesses. Thereafter, the petitioner shall file an affidavit towards completion of such dusty oblique personal service on the respondent numbers 5 to 8. In the meanwhile, if the respondents in the State Bank of India Polarium. It's Polarium, right?
Correct.
Have not sanctioned the loan under the DDUSY 2024-25 to the respondent number 8. The same shall be stayed / kept in abeyance until further order of the court.
Great. Well, the fact of this case is surmises on the fact that the petitioners are 45 in numbers. They are serving as the block education officer under Department of Education. My lord. Now their services were regularized in accordance with judicial directions in WPC number, my lord, 447 and WPC number 598 by this honorable court. Now, they have also framed, my lord, recruitment rules, my lord, 2017. Now, column 10, schedule 10 of the rule says, initial regularization shall be regularization only. Now, another lease, my lord, limb, is that these TCTs, my lord, they were given option to exercise whether you want to be in the block education officers or not. My lord. Then they have exercised their options that we would like to be part of the BEO cadre. My lord. Then next thereafter, my lord, 114 posts of TCTs were converted. And against that conversion post only, we were regularizing. So therefore, my lord, they have regularized 32 number without conducting the reviews. Now, pertinently, my lord, this impugn order has been issued to an extent saying that in compliance with the honorable court order, our services were regularized. Now, my lord knows the consequences. It is a binding upon them to follow the judicial orders and the consequences, my lord. Therefore, my lord, the impugn order, to my understanding, my lord, is not sustainable. We request the interference of this honorable court. My lord, I proceed with the fact, my lord, kindly come to page 360, the impugn order.
Just a minute. Just a minute. Take your seat, Mr. Turner. Yes, Mr. Nabam.
My lord, standing counsel is there, my lord.
Oh,
Mr.
yes,
Tabu will assist.
Mr. Zamu will say, right.
My lord,
Mr. Zamu, pursuant to the order of the court, you have considered those aspects and initially you have regularized 32, right?
my lord,
Because you found that the scale of trained graduate teachers and the block elementary education officers are same. But the qualification of block elementary educational is master degree. And you have also decided that you will give 3 years time to obtain their master degree. Now, what happened after the rules been came into force? What you have done?
my lord, this regularization, my lord, so-called regularization, my lord, that has been cancelled because it has not been done in accordance with the recruitment rule, my lord. Recruitment rule says it should be as per, that there should be DPC manner, that this has not been done through DPC. That is why after having detected this has not been done through DPC, the impugn order has been issued, ma'am. Cancelling, and the impugn order is at page 354. It's clear, madam. The whosoever eligible, man, there will be a fresh DPC, madam, because it was not done on the basis of the DPC, on the basis of the recommendation of DPC.
Please come to page 250. You come to page number 251, 249, the last paragraph.
Yes, madam.
Kindly come.
Two 49, madam.
Right. Last page.
Yes,
Two
madam.
49 last paragraph.
Madam, this is what, madam.
Kindly
This,
read.
this,
Kindly
this.
read. That is the background. Kindly
Yes,
read.
yes, that is better. Now,
And-
this was the case, madam, where the 32 BO, madam, they were already serving prior to this order, madam. Now, the order at operating portion, madam, 250, madam.
No, that is the reason. Okay.
Yes,
Now
madam,
you
that
are
is why, madam,
250.
that is once, but that's why before filing, madam, there is some of those, the petitioner approached this court saying that we have been serving as a BO, but there's no step taken, but the positive step taken by the government to secure their service, madam. That's why, madam, despite of there's a order notification.
Now read page 250.
Now, the
last
page
paragraph.
250, madam, they say that the follow the notification. Till letter in spirit, madam, in respect of petitioner 32, madam. So for rest is concerned, madam, as and when recruitment rules are brought to the effect by
Kindly
the
read
department,
the-
madam,
Mr.
case of review shall be considered
Mr.
regulation accordingly, madam. Madam, that is what,
Listen to us. Kindly read the last paragraph slowly
my lord,
so that you can understand.
last paragraph, madam.
Yes.
Consequently, this writ petition disposed of with direction to the authority to follow the notification dated 28 February 2015, as well as decision taken in a board meeting dated 19/06/2012 in letter and spirit. As and when recruitment rules are brought into effect by department, the case of BEO be considered for regulation in accordance with the provision of rules and as per entitlement under the law. Now, after this matter, recruitment rule
Let us see.
2017 has been come into force, madam, at page
Let us-
318.
Yes.
318, madam. Now, this is after this order, madam. Now, mode of appointment, madam, we'll see at page 39, madam. 10, 11, madam. 10, madam. This is by 100% promotion, madam. First case, my lord, this regulation, my lord, this will in terms of strictly and that the order we have just read, madam. Now, now promotion from the post of now, my lord, the in case of recruitment by promotion or regularization to be made, madam. The minimum, the qualification, my lord, teacher, we have rendered 10 graduate teacher, 10, we have rendered 10 years of regular service in the grade with master degree from Shoncha, madam. Now, departmental promotion committee, madam, the composition is provided. Commissioner, head of office, commissioner, secretary of the other department, not connected to the, this is the manner of composition.
Please come to page 319.
Yes, madam.
Read serial number 10 and the right hand block also. What is serial number 10?
Classification as general Arunachal Pradesh Group B gazetted.
No, 319.
Or 319.
Serial number 10.
10, madam, yes. Method of recruitment, whether by direct recruitment or by promotion and by regularization and percentage of the resource. Madam, this is 100% promotion.
Down on the right hand, 100% promotion. Below that, what is written?
Initial constitution. Madam, initial constitution, madam, it talks about
Kindly read.
by regularization of the existing block education officer age on death of order of the Honorable Court, order dated 10 February 2016, passed in short. That previous one, ma'am. Madam, that was in respect of person who were already serving prior to this order, ma'am. This court's order, ma'am.
So you have to just regularize. Just you have to regularize.
Because at that point, madam, there was no RR, madam. No RR came into force. But after this order, madam, this order RR came into force, madam. That is
Then read 11.
29 August 2017. madam.
Then read 11.
Then 11, madam, by promotion from post of trained graduate teacher, non-graduate, who have rendered 10 years of regular service in the grade with a master degree from recognized university and B.Ed, madam, or diploma in elementary education or equivalent from recognized institute.
Then 12.
12, madam, If departmental promotion committee exists, my lord, there's a composition, DPC composition,
Okay.
the head of department, my lord, and other, but this
Now-
composition that has not been, my lord, compliant.
Now please come to you have to little walk, come to page number 264.
Page number, my lord, 264.
Kindly read.
My lord.
Please read.
My lord. Implementation short, my lord, for the Guwahati High Court on 10 February 2016 passed order in short show in Nabusara and short. Other in the matter of point and block education officer, brief ground of the case, background of the case is as follows. Background: the post was earlier designated as a assistant designated the ABD of PO. The designation was later changed to PO. The PO appointed the PO teacher. The PO is in the administrative post of the education of the PO open all the side description. Present. New.
After 264, you come to 267. 267.
My lord. Meanwhile, representative from the National University Education Planner, New Delhi. Rounded to the computer dispatch.
After you finish 267, come to 268.
Mallet, complying with the application of this. Mallet. Mallet,
Then you come to 69, the last portion. Compliance of the High Court's order,
compliance.
269 and 270.
Yes, madam. Rest 70, madam, should be regularized as per High Court order.
Then you come to page number 271.
Okay.
Right.
My lord.
Now you tell us.
My lord.
Hmm.
This 32, my lord, that was already serving, my lord, existing against the sanction post, my lord.
Whether in the High Court order, they have separated 32 or 101 or any 70, or they have given for all the read petitioners.
My lord, in the High Court order, my lord, 447, my lord. 447, my lord. It's, my lord, first thing, my lord, since at that point of time, my lord, when the order was passed, my lord, the no RR.
See, basically, they approached the court because they were scared that they will be reverted back to the
Yes, yes.
TGTs.
Yes,
That is why they approached this court.
my lord.
And the matter was disposed of because statements were made that no such action has been taken.
And
So
they-
in that background,
yes,
the
madam.
court directed.
Yes, madam, yes. Madam, they were even they were eligible in terms of the length of service also, madam, all respect, madam. So that's why they were apprehension that they may be removed, madam. That's why
They may be
department said that
reverted back to the TGTs or
Madam.
junior teachers, whatever.
they were
Right.
apprehension, on apprehension they
They have approached. The direction is very clear.
Yes, madam. Their direction is clear, madam, since before the RR, madam, recruitment rules frame, madam, there was already a notification that 28th April 2015, madam, at page 223, madam. That is to be followed later in speed, madam. And thereafter, madam, after recruitment is made, madam, recruitment rule is framed, madam, that has to be considered as per recruitment rule, madam. Now the person
So what was the notification of 28th of April 2015?
at page 223, madam, it is the the function and duty of the BEO, madam. 223, madam, page 223. My lord. This is notification 28th April 2015.
True.
Now classification and cadre of BEO. Now existing, my lord, this is who were already serving, madam, at that relevant point. The post classification and cadre, my lord.
Yes, we have seen that.
My lord. But now thereafter, my lord, there are three, my lord, there are three eligibility criteria for recruitment, promotion to block education officer. Minimum educational qualification for post BO shall be master degree with BEd for recruitment, public departmental promotion. Senior most trained graduate teacher under elementary education with requisite qualification shall be eligible for promotion to the post of BO as per recruitment rule. My lord, in that, now after this, my lord, the recruitment rule has been framed, my lord.
See, basically, if court have directed you to regularize their service,
My lord.
keeping in mind that the notification of 28th of April 2015
Yes, madam.
and the decision of the board of 19th of June 2012.
That is, it is in tone with this same notification only. My lord.
Now here, the writ petition was filed by 102 BEOs, right?
Madam.
Is there any separate direction for them that they should be, this 32 should be considered for regularization and the remaining should be considered for regularization through the recruitment rules? Or the entire 102 should be considered through recruitment rules? Was there any separation in that order?
My lord. My lord, this is, my lord, the 100 and, my lord, the 114, my lord. This is, it has been, my lord, this post sanction, the post has been converted from TGT to B.
Because pay scales are same. So only the, instead of TGT, they have, or the postgraduate teacher, they have been converted to BU, that much.
And my lord,
Exercising option from PGT to BEO, my lord. We have been, our cases, my lord, we were sought options, my lord. We gave the options that we would be in the cadre of BEO, and thereafter, 114 post was converted. And on the consent order of the standing council has given.
Standing council has no such right, it is the only the advocate general.
Yes.
That is the law laid down by the apex.
Correct.
It has happened. In Assam, what had happened, there was a process of regularization only because of the standing council education has stated something before the learned single judge. So there was a direction by the learned single judge to
Correct.
regularize all such. But those are all illegally appointed without
Yes.
following section 14 and article 14 and 16.
Correct.
Then the matter came up before the division bench. The division bench said, no, that is not, the standing council has no such right. It is only the advocate general of the
Correct.
state, not even the additional advocate general of the state. Because the advocate general is the part and parcel of the cabinet. So any decision of the cabinet amounts to that, and that's why the submission of the any such sanction or any appointment
There
given
was
by.
an affidavit in this case, my lord.
But anyway, here that is the reason Mr. Tagum tell us.
now that is why, madam, since RR has come into force, my lord. This, all whosoever it may be, but we are not saying that they are, some of them may be eligible, far better.
Then why you have
and
not
some
done
of
with
them
the, why you have
may not be
done-
eligible.
Then why you have not done with the 32?
My lord, that's why. my
Why
lord,
have specified 32 and left out 32? I have they regularized their service and remaining have to go to the RR rules. Why?
my lord, 32 part, my lord, the most of, they were much eligible.
As
Now-
they were working against sanction posts. That's why they did
No.
not go to the recruitment rules. And the remaining persons who were not against the vacancies, so they should go to recruitment rules. What is the reason behind that? The law, the order of the court is very specific. You have to keep it in mind that 28th April 2015 decision notification. You have to keep it in mind the board's decision and to follow the recruitment rules for regularization of their service. Why you have picked and choose? Only because 32 persons have already worked against sanction post. That is why they should not be considered for DPC and the remaining should be reverted back to the trained graduate teachers. And DPC should be there and then you should follow. What is that the direction?
My lord, this whosoever, if whether they are eligible or not in terms of, or whether in terms of their length of service and qualification, that is to be looked into by the DPC, my lord. That is the appropriate, my lord, the authority, my lord, who's to look it up. Now, in this case, without conveying the DPC, my lord, they have been regularized. That's illegal, my lord. That is why, after having realized that this has been done illegally, instead of following the rule, that has not been followed. Accordingly, that has been cancelled. And it is in the impugn order, it's clear that the fresh, there will be a DPC in accordance with the recruitment rule, madam. Since it was not done as per rule, madam. That's why. Only, Malad, why I'm pointing out this impugn order, Malad. Impugn order is clearly, Malad, only on that ground, Malad. This has to be done by the competent authority. That competent authority is the DPC, Malad. Since it has been not that has not been followed, has not been done for DPC. That's why only that account, Malad. Having realized this aspect.
The appointments were made or you have regularized this 100 numbers of you?
Regularization.
This is not appointment.
Not appointment. They have failed to distinguish what is appointment and regularization.
The
I have
orders
taken a
issued by
categorical
annexation
ground
should
on
be
that.
regularized. Mr. Namo, their orders are clear. They have been regularized.
Malad, only the meaning regulation that should be done for DPC only.
No.
There's no other mode of Malad,
Sorry, sir.
regularizing.
No.
There's no other mode, Malad. The person who
Well, DPC, to my understanding,
DPC
is convened only for the purpose of promotion, not the case of regularization. And I have made a categorical ground, I have given a distinction also. What is appointment and what is regularization? My brother is helpless because their own record is speaking out. You have sought our options, we have excised our options. Then thereafter you have converted our post and then you have regularized.
Where is the order of 22nd of April 2021?
22nd.
There are two read petitions.
Yes, yes, Miller. That.
Where is the second read petition order?
320 block.
Where is that?
Page 320 block.
320?
Yes. 2204. Order. Miller.
Order is at page?
It starts from 320 Milot. Kindly come to this. They are also the same thing. They have written. Kindly come to page 328 Milot. There 24 Milot. It says so and so. In WPC number 447 AP 215, this court directed the respondent to follow the notification dated 28/4/2015, as well as a decision taken in the board meeting dated 19/6/2012 in latter instance. Now, the present writ petition has been filed with a prayer that a time limit has to be given for implementation of aforesaid directions of the court. Today, Mr. Jamo has handed over a letter containing written instructions that the department would not have any problem in implementing the notification 28/4/2015. Milord. It is their consent order, Milord. On the standing council is nothing to do with. They came out with the instructions and said we will implement it, Milord. And Milord, their department's conduct has not been very clean, Milord. Absolutely exercise the executive power in the most arbitrary and mala fide manner. Milord, that my lord will discernible from page 330, Milord, Annexure 9, IAC 177/2022, Milord. They sought time frame when the contempt petition was filed. They sought time and then this honorable court was not pleased to grant them the time. Page 341 is the operating portion. With gracious indulgence of Lordship, I read this operating portion only. In view of the above and having regard to the fact that 6 months extension of time for implementing the order passed by this court has been sought for to an order which was passed as far as back as on 22/4/2021 in WPC number 596 AP stroke 2018, that too on production of written instruction by the Learned Standing Council for Education Department, that the department would not have any problem in implementing the notification dated 28/4/2015. I am not inclined to grant any extension of time as sought for. 341. Page 3. And thereafter, Milord, what they have done is, they have converted our post, Milord. Milord will kindly come to Annexure 10, Milord. 342, page 342. Because after the option, Milord, we were already part of the BEO cadre. 6 January 2023 order, Milord, page 344 says, the governor of Arunachal Pradesh is pleased to accord for conversion of 114 posts of TZTs to BEOs under the Directorate of Elementary Education, Government of Arunachal Pradesh, as per cabinet decision dated so and so, 21st December 2022, in compliance with the direction of Honorable High Court Order WPC number 596 AP 2018, dated so and so. And my lord, kindly see the impugn order has even overridden the
Mr. Tell us how many of these doesn't have the postgraduate degrees?
My lord, for that, my lord, my instruction, I have to seek my instruction.
But I have
Come to page number 223.
My lord. 223, my lord.
Read the eligibility criteria.
But eligibility criteria is there. Is it, that is, madam, whether, how many,
Kindly read.
the minimum qualification for the post of BO shall be the master degree with B.Ed for recruitment oblique departmental promotion. Senior most trained graduate teacher under elementary education with requisite qualification shall be eligible for promotion to the post of BO as per recruitment rule. In case of present incumbent BO not having postgraduate degree, a 3 years time shall be the given for completing postgraduate with B.Ed. It is a proper avenue for promotion of B.Ed shall also be specified. Detailed rules and norms of promotion shall be carried out after consultation with Madam, this part, madam, is there, madam.
Now the court while disposing of the repetition at first in 2016 clarified that you have to adhere to this particular
Yes.
provision and the rules that you are likely to
Yes.
frame, right?
Yes.
Now, rightly, wrongly, whatever, you have regularized your service.
Madam.
Now you have a fact-finding committee who's found that they have been regularized, but without having the eligibility,
Madam.
right?
Madam. That's
Law
why
is very
this
clear.
fact has, now that is why, madam, these certain fact, but that's only revealed from the report only, madam.
Now,
Who
if-
among the,
If some of the BOs whose services have been regularized without having the eligibility,
madam,
first of all, you have sought out them. You
Madam, that is-
cannot revert back all of them to the TGT.
madam, that
First
is
of all, you have to do it with other person doesn't have
Correct.
the qualification.
absolutely correct. Madam,
As per the 2015 notification as well as per the recruitment rules, who are not eligible to hold the post of BEO. First of all, you have to, because your fact finding committee have already given this,
madam,
but what you have done? Instead of that, you have reverted all them to
Madam.
because your condition is that you have to have the DPC.
madam.
That is not
Madam,
the case.
this,
See, basically, Mr. Samo, the Honorable Apex Court clarified, if somebody doesn't have the eligibility to hold a post, he cannot hold a post.
that is why, that is why.
Right.
This,
But if there's if and parts of this office, right, we simply cannot jump on that. If somebody is not happy with what is there, that is also been prescribed by the court. You have to work with
right,
your
right, man, right.
Right.
Correct.
Without the eligibility, no one can have.
Well,
it.
my brother need not to take pain because in
Right.
paragraph 4 of my
It is very clear who are the persons who have not, doesn't have the PGT degree as required. The law is very clear, the observation by the decision is very clear that you have to give them 3 years of time.
Madam,
That's all.
Madam, that's why these, despite of having this notification, madam, this, that has
Why
not been
do
adhered
you
to.
want to revert back to TGT? Because the pay scale is same. Only those who doesn't have the qualification or the postgraduate degree, you ask them to have 3 years.
Only status, madam. Now, in KBO is gazetted, madam. In TGT is non-gazetted, although Group B is same, but Group B gazetted and non-gazetted. That's the only difference. Now, that's why, madam. Altogether, this anomalies can be, has arose because that this has, had this been placed before the DPC,
That is
there
not,
could have been,
that is not required.
My brother will
For this
kindly
order.
kindly interfere with this.
Heard Mr. Tirithara and counsel appearing for the petitioners. Also heard Mr. Arish Nawam, learned additional advocate general, Arunachal Pradesh, for the respondent numbers
one.
1 and Mr. T. Jamu.
Madam, T Tagum, Tabat Tagum.
Right. Learned
Earlier it was
standing-
Jamo, madam.
Now it is
That's why.
standing council education. For the respondent numbers 2 to 4. The contention of the petitioners herein are that pursuant to the order of the court dated ten zero to 2016, passed in WPC number 447 AP 2015, as well as in the order dated 22042021, passed in WPC number 596, within bracket AP oblique 2021, and contempt case number C 71/2021. The service of the petitioners have been regularized as block elementary education officers following the notification dated 28/4/2015, notification number SCDN/81/2014, dated 28/04/2015 of the Chief Secretary of the State, as well as the decision of the board dated 19/06/2012 by orders dated 03/01/2024. Subsequent to that, by another order dated 11/04/2025 by the by the impugn order dated 11/04/2025 under number EED-12040/10/2023, issued by the Commissioner within bracket Education, Government of Provisional Pradesh on 16/04/2025. Revoked the earlier order of regularization of the petitioners as BEO and reverting them to the original post of trained graduate teachers, stating that a committee that was duly constituted by order dated 4/9/2024, while examining the process of appointment of the TZTs to the post of BEO in the Education Department, found that all the BEOs appointed in the year 2024 did not comply with the provisions of the BEO recruitment rules modified on 29/08/2017, nor with the notification dated 28/04/2015. Observing that the appointment to the post of BEOs can be made only by a regular departmental promotion, by convening a regular departmental promotion committee as per the BEO recruitment rules. Issue notice returnable by 28th of May as Mr. Nabam such and such for respondent number 1 and Mr. such and such Tagum, understanding council such and such for the respondent number 2 and 4, 2 to 4. 2 to 4 or 2 to 3? 2 and 3, I think so. No formal notice need to be issued. Petitioners shall serve requisite extra copies to such and such. On or before 08/05/2025, obtaining necessary acknowledgement from them in that regard. Not 08, by tomorrow, 07. Till the returnable date, the impugned decision or impugned order number EED-12040/10/2023, dated 11/04/2025, issued by the Commissioner within bracket Education, issued on 16/04/2025 shall remain suspended. Next, you write. On the returnable date, the respondents in the education department shall apprise the court as to how many of the petitioners doesn't have the requisite educational qualification for the post of block elementary education officer in terms of the BEO recruitment rules.
May I make a small request instead of 28, this week I will not be there on 5th of June.
Not
Madam,
much.
please,
Just a minute. Let's see 7, 14, 21, 26th, Monday.
Well,
No.
Twenty-five, 24, Lordship.
Hmm.
Can this matter be taken up after 2 weeks, Lordship? Much obliged, Lordship.
After 2 weeks, on a date to be fixed by the registrar. No.
Much obliged.
well, May it please your lordship. Lordship, in this instant writ petition, the petitioner has assailed the impugned transfer posting order dated 29/10/2024, which is at page 24, lordship, whereby the petitioner who is serving as executive engineer at Urban Department, Poleng, has been transferred and posted to the office of Chief Engineer, Urban Development and Housing, Itanagar. Now, lordship, the basic ground on which the petitioner has assailed this impugned transfer posting order is the private respondent who has been transferred and posted in place of the petitioner is not in the substantive post of executive engineer. In fact, the private respondent is holding the substantive post of assistant engineer, lordship. Now she is and the transfer posting has been effected in the manner that in fact the private respondent has been shown as executive engineer. However, in fact, she is the private respondent is just holding the post as in charge. Now, with regards to this, lordship, this issue came up before the coordinate bench of this honorable court in the case of Nyapung Konya versus State of Arunachal, and subsequently in the case of Hibutama versus State of Arunachal Pradesh. Now, in those two cases, lordship, the coordinate bench of this honorable court has held that there cannot be a inter-se transfer between those who are not similarly placed in the department. So this matter has been, it's a cover case, lordship. And since all the parties has filed their respective affidavit, may I pray that your lordship may issue rule and fix this matter for hearing, lordship.
You are Mr.
Lordship?
Taban Tabing,
Yes, lordship.
transferred when?
Transferred on 29/10/2024, lordship. Page 24, lordship, is the impugned transfer order.
Prior to this, when you were posted at Bolem, when you were posted at Bolem?
Lordship, that has not been enclosed, lordship. Initially, he was transferred and posted from rowing, lordship, rowing division.
You are serving at bowling since when?
Since oh, Gopal. Lordship, 14/10/2020. It's in the government affidavit filed by the government. Lordship, another ground is I'm on the verge of retirement. Initially, when this transfer posting order was issued, I just have 16 months. Now, during the pendency, just 11 months is left.
Mr. Nabam, do you have the records? You put directed earlier to have the records. Do you have the records with you?
record लाया कौन सा आपका record मतलब लगा नहीं record नहीं लिया वो ये फाइल कर दिया फिर फाइल कर डिपार्टमेंट जो फिर फाइल कर कोर्ट का डायरेक्शन
My lord. I'm sorry, yet to procure that recruitment records, my lord. Anyway, my lord, we have filed the affidavit, my lord, giving the reason why we have transferred him, my lord. My lord, as per the policy, transfer policy guidelines, my lord, the petitioner has only completed the normal tenure of 2 years, my lord. Now, my lord, there is another notification wherein, my lord, retiring officer, my lord, prior to 1 year, they should be transferred to the headquarters, my lord, so that they can arrange themselves for the retirement benefit, all documentation, etc. my lord. That is the only reason why, my lord, the petition was transferred to chief engineer as a SW, my lord. So SW is, my lord, is equivalent status to my executive engineer, my lord. That is the only reason, my lord. Now, my lord, how can the petitioner say, my lord, the private hospital qualified or not qualified, holding the same regular or not regular, my lord? Whether, my lord, that thing will, my lord, will affect the any fundamental right of the petitioner or not, my lord, or any right has been violated or not, my lord. That has to be seen, my lord. Now, my lord, another, my lord, he has referred to that Hibu Tamang case. My lord, my understanding, that is not a good law laid down by the learned single judge. However, my lord, As on that, my lord, that really stands, my lord. There is no any appeal against the judgment. Wherein, my lord, only regular can replace by regular, my lord. I don't see any logic of the judgment. But in this case, my lord, no any fundamental right of the petitioner has been violated, my lord. It's a transfer policy, not only prerogative, my lord, it was for his betterment, my lord. So that is the only reason, my lord, why he has been transferred to the headquarters, my lord. If your lordship give me some more time, my lord, I can edit the document records, my lord. There should not be any problem. And the private respondent, my lord, she has already assumed the duty. I think she is discharging, my lord. Right. Is there any issue, my lord? If your lordship is perusing the government affidavit, my lord.
I have
Your
seen that. Just
Your lordship may kindly say the paragraph 6, my lord. That is the reason given by the department.
Please take your post. Please take your post. You are Mr.
Etaka close.
Etala. Yes, what do you have to say?
My lord, I am for previous respondent number 3, ma'am. My lord, if possible, it may be disposed of today, ma'am.
What's your good name?
Yes,
What's your good name?
if possible, my lord, this,
What is your good name?
Arriva, my lord, Remo Riva.
Heard Mr. Etala, Learned Counsel appearing for the petitioner. And Mr. R.H. Navam, Learned Additional Advocate General, Arunachal Pradesh, appearing for the respondent numbers 1 and 2. Also heard Mr. Such and such Learned Counsel appearing for the respondent number 3. Petitioner Tabin is an executive engineer in the Urban Affairs Department of the state. On his own request, the responding authorities in the Urban Affairs Department of the state, by an order under memo number DUD/E STT-459/2010/11/3563-74 dated 12/10/2020, issued on 14/10/2020, transferred the petitioner from rowing division and posted him at bowling division. Since then, the petitioner is serving at bowling division. By the impugn order under memo number SUDH-11/16/2024 SUDH-UDH/618 dated 27/10/2024, issued on 29/10/2024. The Commissioner, Urban Affairs, respondent number 1, transferred the petitioner from bowling division and posted him as in charge of surveyor of works in the office of the chief engineer, urban development and housing at Itadega. But he said impugn transfer order dated 27/10/2024, issued on 29/10/2024, The respondent number 1 transferred the respondent number 3 surveyor works, insert surveyor works in the office of the chief engineer within bracket UDNH, Itanagar, and posted him as an executive engineer to Bowling Division. Agreed with the said transfer order, dated 2017-2024, issued by the respondent number 1 noted above. The petitioner filed this writ petition on (21) 11/2024, praying amongst others to person set aside the said input transfer order of the petitioner dated 27/10/2000, issued on 29/10/2024. The petitioner also prayed for an interim prayer to stay the input transfer order and posting dated 29/10/2024, noted above. The court, while issuing notice to the respondents, on 22/11/2024, in the interim, directed the responding authorities in the urban affairs, Government of Arunachal Pradesh, not to give effect to the said transfer order of the petitioner dated 2019-2024, which is still in force. The contention of the petitioner is that the coordinate bench of this court in the cases of Niapong Konia, paragraph 12, page 15, no? That's it. Versus State of Arunachal Pradesh, WPC number 257 AP 2016, and Sri Hibu Tama versus State of Arunachal Pradesh and others, WPC number AP 2006, have held that there cannot be an inter se transfer between officers who are not similarly placed officers in the department. Since the petitioner himself is an executive engineer, will be in the Urban Affairs Department of the state, whereas the respondent number 3 is only an assistant engineer. As such, pursuant to the decision, coordinate bench of this court passed in Niapang Konia, Supra, and Hibutama, Supra, the impul order of his transfer dated 2017-2024, issued on 29/10/2024, transferring him from Bolerian to such and such to Korean, needs to be interference. The state respondents 1 and 2 have filed its affidavit on 26/03/2025, serving a copy of the same on the counsel for the petition. However, till date, the petitioner did not file any reason to the said affidavit of the state respondent. In the affidavit filed by the state respondent,
admitted that response number 3 is the response number 3 insert executive engineer, office of the chief engineer, in the office of the chief engineer, urban development housing, Utanagar, has been transferred and posted as executive engineer. Following UD division against the petitioner, and that the petitioner has been addressed in the office of the chief engineer, urban development, in the public interest by the interim order of transfer dated 27/10/2024, issued on 29/10/2024. The state respondent also specified that the transfer and posting of an officer is a prerogative of the government that are made in the exigency of works and interest of public service, which are incidents to government service. The respondents further clarified that a petitioner was serving as an executive engineer at Bowling UD division since 14/10/2020 and have completed more than 4 years in the same place of posting, though as per normal tenure, a government employee in a particular place of posting is for 2 years TWO. The state respondents further clarified that the response number 3 that pursuant to the interim transfer order dated 27/10/2024, issued on 29/10/2024, the response number 3 has already been released from the office of the chief engineer within bracket UD and housing, Itanagar, and has joined her service at Bowling UD division on 11/10/2024. But the petitioner did not hand over charge to the said respondent. In that regard, the respondents have already placed the release order of the response number 3 dated 31/10/2024, issued on 01/11/2024, and his joining report dated 11/10/2024 before the chief engineer. Joining report at Bowling. The response number 3 has also filed an affidavit in this matter. Stating that since the pursuant to the order at the 29/03/2023,
issued by the respondent authorities. She is serving as an executive engineer she is serving as executive engineer slash surveyor of works plus one. That is a grade one, capital Roman one. That is equivalent to the post of executive engineer at the office of the chief engineer, urban development housing at Itanagar. She also stated that pursuant to the impugned transfer order dated 27/10 issued 10/2024 issued on 29/10/2024. She was released from the office of the chief engineer, UDN housing at Itanagar. And on 1st of November 2024, and has submitted her joining report at Bowling on 11/11/2024. And at this stage, if the impugned transfer is interfered with, interfere with the business, should not interfere with, should not be interfered with. The response number 3. Also placed before the court that as per the initial service record, the date of birth of the petitioner is 14/12/1961. Who should have retired from service in December 2021 on attaining the age of superannuation at 60 years. But shockingly, he is holding the service and enjoying the salaries and all of the benefits and allowances of regular services till date. In that regard, the WPC number 280/2024 against the petitioner is presently pending for adjudication. That was preferred by one Ramu Eli, an executive engineer. As such, it is submitted by the respondent number 3 that the petitioner has no such right to challenge the impugned transfer order dated 27/10/2024 issued on 29/10/2024. It is also seen that though the respondent number 3 filed its affidavit on 28/01/2025 by serving a copy of the same on the counsel for the petitioner, the petitioner did not file any rejoinder / counterclaim to the affidavit of the respondent number 3. In the affidavit filed by the respondents, official respondents, This it is submitted that since the petitioner is retiring from service on 31/03/2026 as per his class 10 pass certificate submitted by the petitioner, he has been posted as surveyor of works in the office of the chief engineer, urban development and housing at Itanagar, so that he could engage in his pension paper preparation works as the Director of Accounts and Treasuries, audit and pension offices are located Itanagar and Naharlagun respectively. And for such convenience of the petitioner, he has been transferred from Bolerang division and posted at Itanagar. From the influence transfer order, there are 27/10/2024 issued on 29/10/2024, transferring the petitioner from Boleng division as surveyor of works, that's capital room 1. Huh? Don't write insides earlier. I have written some insides. It's like SW1, surveyor of works, capital room 1. In the office of the chief engineer, urban development and housing in Itanagar, it can be seen that the same has been issued in the interest of public service. The petitioner, in this writ petition, did not allege that the impugned order of his transfer has been issued mala fide or to favor the respondent number 3.
Sorry for interruption, my lord.
But only
16.
the
There are 16.
ground taken by the petitioner is that the respondent number 3, who is to replace him at Boleng, is not an executive engineer, but an assistant engineer.
There are 16, my lord. It has
The-
it's stated in para 16.
Though the petitioner alleged that the transfer and posting of the respondent number 3, substituting him at Boleng, is illegal and arbitrary, and only to accommodate the private respondent number 3. But in that regard, the petitioner did not place any material before the court to accept that contention, to accept his said contention. Moreover, in this petition, the petitioner did not state since when he is serving at Boleng, and particularly remain silent with regard to his order of transfer at his own request issued on 12/10/2020, posting him, transferring him from rowing division and posting him at bowling division. Further, the petitioner filed this writ petition after the impugned transfer order dated 27/10/2024 issued on 29/10/2024 has come into effect, as the response number 3 was already released from Itanagar on 01/11/2024 and he joined at bowling on 11/11/2024, and to that extent petitioner remained silent in this writ petition. Law is well settled that transfer and posting of a government employee is within the discretion of the government. In the case in hand, the impugned transfer order was issued in the interest of public service. Further, the petitioner had completed more than 4 years of service at bowling. Moreover, this writ petition was filed on 21/11/2024. Writ petitions filed by the petition. And impugned order was passed on 22/11/2024. Interim order was passed on 22/11/2024, whereas the response number 3 was already relieved from the office of the Chief Engineer, UDNH Itanagar on 01/11/2024, and he joined at Bowling Division on 11/11/2024. Considering such materials in the case records placed before the court and considering the entire respective matter, this court is of the view that the impugned order of transfer of the petitioner, the 27/10/2024 under number such and such and such, issued on 29/10/2024, cannot be interfered in exercise of the power under Article 226 of the Constitution. And accordingly, this writ petition, being devoid of merit, stands dismissed. However, considering the fact that the petitioner, on attaining the age of superannuation, shall retire from service in March 2026, he may file a representation before the Commissioner within bracket Urban Affairs, Government of Arunachal Pradesh, Itanagar, after joining as Surveyor of Works, Tax Capital Roman 1 in the office of the Chief Engineer within bracket UDNH Itanagar. In the event of filing such representation by the petitioner, the Commissioner, Urban Affairs, Department, Government of Arunachal Pradesh, shall consider the same in accordance with you.
Deeply obliged.
There is a specific judgment, in fact, a full bench judgment, you can say, of the Honorable Apex Court, where clearly written that no such transfer order has to be considered if a person has already completed his tenure. That can be considered when the incumbent should join his first
Place of posting.
post of transfer and posting. Then he may file a representation, which may be considered.
Deeply obliged.
Just to add, in view of the above, the interim order first on such and such stands vacated, recalled. Yes, Mr. Tarek, what's the matter about?
Well, the case in nutshell is that the petitioner has superannuated from the service on 17/12/21. Then thereafter, he got a clearance certificate on 24/11/2021. Then obtained the vigilance clearance certificate from the undersecretary, so and so forth. But, you know, there is a criminal case pending against him. So that, so the NOC was not granted and the pension papers was not submitted. So, my lord, to be very fair side, the Rule 9 of the CCS Pension Rule 1972 clearly holds that once it is charge sheeted or the criminal case has not attained finality, in that even the president or the governor at their pleasure can withhold the pension partly or fully, my lord. But in this case, my lord, the things has gone little beyond the periphery of this pension rule. For that, my lord, the charge sheet has been filed. However, that does not bar the state government, my lord, from granting the provisional pension, my lord. And that particular, my lord, kindly see the affidavit in opposition filed by the respondent number 2. My lord, kindly say that they have granted me provisional pension, my lord.
So you are getting provisional pension?
No, my lord, no. After this, kindly come to page 56, my lord. Only for the AO by the R2, my lord. It says, my lord, 12th March order, 2023. Approval is hereby accorded to grant of provisional pension for 6 months with effect from so and so to so and so retired APCS admin grade, the then Deputy Commissioner Pakikesang District, who retired on superannuation with effect from so and so. The provisional pension is subject to adjustment in the final payment by the Directorate of Audit and Pension, Government of Arunachal Pradesh. When I post there, you know, there are two things. Firstly, no vigilance clearances was given. So therefore, the pension paper has not been reached to the Department of Pension and Audit, Milord. And that is categorically stated by the respondent number 3. The Director of Audit and Pension, Milord, will kindly come. They have
No, they cannot, since the criminal matter is presently pending.
Yeah,
the
yes.
procedure-
Now, my lord,
with the clearance also.
yeah. Now, my lord, the Rule 64, my lord, comes into my rescue, my lord. CCS pension rules. Oh, this is 64 to like that. Pension rules. Down to there.
Yes.
Now, my lord, Rule 64 says provisional pension for reasons other than departmental or judicial proceedings. Now, in that even, my lord, kindly come straight to Rule 6, my lord. If the final amount of pension and gratuity have not been determined by the head of office in consultation with the account officer within a period of 6 months, referred to in clause A of sub-rule 5, the account officer shall treat the provisional pension and gratuity as final and issue pension payment order immediately on expiry of the period of 6 months. As my lord, I have taken kind indulgence to page 56 of the affidavit in opposition by the respondent number 2. They have given me a provisional pension of 6 months and this has been continued, my lord. So therefore, my lord, Rule 64, sub rule 6 of the CCS pension rules comes in my rescue, my lord. But today I will not press anything on the merit. A person has retired, my lord, is on the verge of starvation, is not getting any pension, my lord. Kindly direct them to grant the provisional pension. Monthly provisional pension.
Instruction,
Regarding
because
property.
initially you had given only for 6 months.
Yes, my lord.
Which has been discontinued.
Yes, my lord. After 2022, my lord.
Right.
Our High Court has already decided in this, my lord, 2010.
Heard Mr. T.T. Terrell, learned counsel appearing for the petition. And I'm a Sachin Church. Learned government advocate ownership for this. Appearing for the state respondent numbers.
Yeah. 90.
All, I think so. You'll be appearing for all?
Yes, ma'am.
For respondent, all the official respondents number 1, DO3. On attaining the age of superannuation at the age of 60 years, the petitioner an Arunachal Pradesh civil service officer in the administration grade Deputy Commissioner, Pake Kesang District. What is the headquarter of Pake Kesang?
Limi, my lord, that.
Okay.
I come from that beautiful valley.
Retired from service on 31/12/2021. However, due to continuation of the criminal case against him, in which charge sheet has already been filed, as no vigilance clearance was given to him, the pension papers and the service book of the petitioner has not been submitted or have not been submitted before the Directorate of Audit and Pension for the process of pension of the petitioner till date. Mr. Tara, Land Council appearing for the petitioner submitted that he did not receive any provisional pension that was given to him only for few months.
6 months.
We are not specifying anything. Mr. Tara also placed the provisions of Rule 64 of the Central Civil Service Rules. Central Civil Services, within bracket pension, bracket close rules 1972. Which provision, 5 or 4?
64-6.
Where Rule 64 in bracket 6 of say 1970 provides as follows. I'll just mark it in this book, page 703. In the affidavit filed by the state respondents, on perusal of the affidavit filed by the state respondents on 04022025, it is seen that the state government, by an order dated 12/03/2023, granted provisional pension amounting to rupees 90,025 to the petitioner under CCS pension rules within bracket rule 69(1) within bracket small a, which was only for 6 months. Indicating that the said provisional pension shall be subject to adjustment in the final payment by the Director of Audit and Pension, Government of Arunachal Pradesh. However, such provisional pension to the petitioner after 6 months, i.e., with effect from 01/07/2023, not 22, I think so. He retired on 2022, 01/07/2022 has been discontinued. List on 21st of May, enabling the respondent number 1, Chief Secretary, Government of Arunachal Pradesh, as well as the respondent number 2, Commissioner/Secretary, Personnel, Government of Arunachal Pradesh, to apprise the court about the entitlement of provisional pension by the petitioner with effect from 01/07/2022 in terms of the provision of Rule 64 within bracket 6 of the Central Civil Service Pension Rules 1972. A copy of this order be furnished to such and such for her necessary use and onward communication to the respondents number 1 and 2. List accordingly. Much less.
Yes, and well.
Yes,
And bring some more time, my lord, to file opinion portion in this.
Can you tell us where is
Pardon, my lord.
Mr. Protocol file? Where is the other file? Thank you. Process of reporters.
In, my lord, in term of my lord,
Okay. Okay. What's your good name?
T.Y. Bhutia.
Land Council appearing for the petition. And Mr. L. Perme, Standing Council Power Department. Appearing for all the respondents number 1 to 7.
my lord,
2 to 7.
2 to 7, my lord. One will
Okay.
be a statement.
Any government advocate here? Put her name for the respondent number 1 and Mr. L. Perme. Standing Council Power Department for the respondent numbers 2 to 7. Peruse the office note. Dated 05/12/2024. Also peruse the report of the process server. It is seen that the respondent number 8 has refused to accept the notice. As such, it is clear that the respondent number 8 was aware of the contention of this writ petition and notice on the respondent number 8 is presumed to be served. Service of notice and accordingly on the respondents, including the private respondent number 8, is complete. Henceforth, this proceeding against the respondent number 8 shall proceed for the reasons above, expertise. Notice in this case was issued on 26/06/2023. Matter relates to rejecting the better claim of the petitioner in the trade test dated 23/10/2017 by the Departmental Promotion Committee and considering the respondent number 8 above the petitioner for his promotion. The respondents number 1 to 7 shall file the respective affidavits on or before 30th of May without fail. Serving copies of the same on the council for the petition. List on 4th of June. Failure on the part of the petition respondent numbers 1 and 2 to 7 to file their respective affidavits. This writ petition shall proceed on or before 30/06/30/05/2025. This writ petition shall proceed ex parte against those respondents. Considering the fact that the notice in this case was issued way back on 26/06/2023, noted above.
Obviously.
My lordship. Lordship, hearing I am appearing on behalf of leading counsel J. Gini, your lordship. He has some personal difficulties today, your lordships. This matter may be taken up tomorrow, your lordship.
On the prayer of the counsel for the petitioner, list on 14th of May.
Oblige.
The Tata's report was called for in this case as to whether the petitioners have withdrawn the EMD before filing of the petition. That much.
Any idea? Have you
My
got the
lord,
information?
yes, my lord, I have the records, my lord. Now, my lord,
Whether they have withdrawn?
my lord, that way, my lord, Mr. Tara is correct, my lord. They have withdrawn it. Absolutely.
If he has withdrawn, then no
But-
cases.
But other side, my lord, how far, my lord, Tara's client is very clean or not, my lord. Now, my lord,
But-
as per this record, I will produce before your lordship for perusal. My lord, the things are, my lord, either way, my lord, is same, my lord. Petitioner, my lord, they have admittedly, they have withdrawn, my lord, their EMD. And the allegation made by the petitioner that respondent, my lord, they have not submitted the EMD. That is also correct, my lord.
Hmm.
Now, these are the two things, my lord. Now, I will not say, my lord, who is more black, my lord. They both are black, my lord. My lord, I have the records, my lord, registered issued by them, my lord. This is the,
Where it has been listed for orders.
only for to take this instruction, my lord, whether, my lord, the petitioner, they withdrew the EMD or not, my lord. For that purpose, my lord.
Before filing of the petition, suppressing the material fact, meaning thereby no legal and fundamental rights of the petitioner have been violated, and they have no offers to petition.
Okay.
Now, my lord, situation is like this, my lord.
What will make it?
Then, my lord, under these circumstances, my lord, can I ask, my lord, your lordship may allow us to go for fresh tender, my lord?
That
No,
should
no,
be the-
Why I'm saying, my lord? Because, my lord,
it will-
the department, they have given me the records, my lord. Now, as per this, my lord, the respondent, my lord, they have not submitted the EMD. my lord.
clarify.
So that way, the allegation made by the petitioner may be correct, my lord.
Affidavit as to whether the government has taken a decision to retender or not.
Mr. Tara, hold on.
Retender.
Hard MS.
I'm only submit based on the records, that's all.
Preparing for the petition.
So that way, my lord, both, my lord,
And
petitioner
Mr.
and respondent, they have concealed the facts, my lord.
Petitioner Slippigo. And Mr. R.H. Nabam, Lord Additional Advocate General.
Yes.
Arunachal Pradesh. For the respondent numbers 1 to 5,
I'm sorry, my lord,
will be for 1 to 5,
1 to 5, correct me. 1,
1 to 5 or 1 to 6?
my lord, as per record, my lord, 1 to 5, it should be, my lord.
No, because
Two
the
cases are there, my lord.
District Food and Civil Supplies,
My lord,
come member secretary tender evaluation. That is respondent number 6.
respond number 6. If your lordship taking up, my lord, 1111, then your lordship is correct, my lord.
It has to be,
There are two petitions, my lord.
it has to be
If
from
it is 1111, then your lordship is correct. I'm representing 1 to 6, my lord.
1 to 6.
Correct, my
1
lord.
to 6.
And for 7.
Who is for 8?
8, 10, 9. Two petitions.
In item number 17, you are for 8 and 9. Mr. K.D. Tara, 7. And in item number 18? 7 and 8. 7 and 8. Okay. Right. What's your good name? Dejuntali. On instruction, pursuant to the order of the court, dated
That is 28.
28/04/2025, Welcome. Peruse the detailed order dated 01042025 passed earlier in these proceedings. These Likiba, THE. Pursuant to the order dated 28042025. Mr. Nawab Lani, Additional Advocate General, obtained the relevant instruction and submitted that the petitioner of WPC number 111/2025 had withdrawn the earnest money deposited with its tender involved in this procedure. Lest this matter for admission on 15th of May.
15 May, madam.
Any difficulty? Or you want the week thereafter?
15 years, today is 6. 15. Can it be, madam, 20, madam?
20.
20, madam. 20.
I'm there.
List on 2005. The interim order passed earlier on
1st April.
01042025 shall remain in force
Well, why you vacate that? Because
until further order of the court. Because see, this is an order unless this has to be considered. There is the clear finding about the respondents that they have not complied with. So that is an order, we have to review it. We are not reviewing it at this stage. 1425.
then, my lord, so
That is why on 28th, let it doesn't matter. 142025 is a proper, there is a specific finding which we cannot just brush aside like this.
on 11/2, before filing the writ petition, well, just I have seen from his record only. 11/2,
Let us see.
the EMD was withdrawn.
The next, that
On
is
20, my
the
lord.
for admission.
Yes.
This one.
5th August.
Wait, Your Lordship.
Yes, Mr. Pange.
Well, the IA number 117/2025 has been filed, my lord, challenging an advertisement that was issued during the pendency of the writ petition. Now, if your lordship may kindly have page 14 of the IA, my lord.
Mr. Pange. Say, last occasion, it was in 1st May.
In the writ petition, madam.
Arunachal Pradesh Staff Selection Board has been included as respond number 5.
Yes. I am given to understand Mr. Tapin represents the Honorable Steps Selection Board.
You can just, by filing an additional affidavit, 2 lines affidavit in view of the order passed. Here it is not a party.
That is, I filed the IA minor for a different reason.
We have seen that, yes, because that since there is a proper party as respondent number 5 in the WBC 571 AP.
I don't know, Mr. Government has been served, Mr. Tapin is also the senior government advocate. This is only law points minor. Can the government minor make reservations on the basis of domicile?
That is,
No, minor.
we have fixed the matter on 8, right? So,
The examination starts from 15. Minor, prima facie, minor, if your
Yes,
lordship
this-
permits me half a minute, minor.
no, since this matter is the main repetition is coming up on 8, only for that purpose, we have already directed the chief secretary to clarify.
Well,
So it will let it be on 8, so no issues.
minor, let the IA be fixed on 12 then, minor. Because there's an exam coming up, minor. Ultimately, minor, there are.
We'll fix it on 12, no problem. Let the revision come on 8. Therefore,
Yes.
tomorrow it is coming. List this matter along with the connected WPC number 571 AP 2024 on 8 of May.
This is a case, my lord. Continuously, well, if I will just, my lord, give a background. Earlier case, my lord, somehow they had been withdrawn, my lord. We have filed it. In the meantime, one advertisement has already gone, my lord, district was reserved.
Now this-
Unconstitutional, my lord.
Another advertisement is giving.
Yes.
That I have seen.
Hmm.
We get it on Monday, Wednesday, Thursday.
My lord will accommodate me on 8th, my lord, because I will not be here. Somebody will make a
Your
prayer
junior,
for 12,
yes,
my lord.
let your junior make a prayer on that day, but we are getting some instructions from the chief secretary.
Yes.
So let that part be over in the
Yes.
connected with petition.
Ultimately, when in the earlier review, they filed an affidavit. But what affidavit can they file? Ultimately, it's the interpretation of Constitution. 16(3), Supreme Court Constitution bench is not permissible. Why we have an executive order, my lord. Even the legislature is not permitted. That is what they are doing.
Let us see.
Political
We are not saying at this moment, we are not passing any comment on
Minor.
that, right?
Okay.
Item number 21 and 22.
My lord, I am appearing on behalf of the applicant, my lord. We have moved an implement application in the main writ petition, my lord. What has happened in this, my lord? That petitioner has challenged an order dated 13th of March 2025 issued by the nominated authority of Ministry of Power. As that order is, my lord, as at page number 159 of the paper, main writ petition, my lord. In that, my lord, I am the qualified bidder, my lord, technically qualified, and the petitioner has been disqualified. And the same was challenged by the petitioner in this instant writ petition without
You are
implementing
saying,
as a-
in the, which petition? WPC number
109, my lord.
109 have only page up to 138.
My lord, it's annexure 3, my lord. It might be one. It's annexure 3, my lord.
Annexure 3.
My lord. List of
Order of 13th of March 2025.
my lord.
Yes.
Yes,
What
my
do
lord.
you-
So
please
in
tell us.
So, my lord, in that, at serial number 30, my lord, my name has been mentioned, PRA Nuravi Coal Mining Limited. I have been technically qualified bidder, my lord.
You are PRA Nuravi Coal Mining Limited.
My lord.
Yes.
And the petitioner is a disqualified bidder, my lord. And this order has been challenged by writ petition number 109, APU of 2025. This writ petition was listed on 17th of March 2025.
Now, where is his order of disqualification?
My lord.
Because his name did not figure in it.
True, my lord. Correct.
Okay. Now, he also participated for the auction sale of Namsik West.
Yes, my lord.
Okay, fine.
Now, the writ petition was listed on 17th of March 2025, wherein this honorable court has stayed this order without assigning any reason and without impleading me as a necessary party. The petitioner has mislead this court on 17th March 2025. And the same was challenged by me
Okay, fine.
through writ appeal number 17 of 2025, my lord. And
Writ
through
appeal number
17 of 2025.
Any order passed?
Yes, my lord. I request my learned colleague to hand over the order. In this, my lord, in IA number 90 of 2025, the order dated 17th of March 2025 was stayed with certain condition, which we have already fulfilled, my lord.
In fact, this appeal could have been, when it is fixed,
On 21st, but this appeal could now be disposed of, my lord. But for that, we need to be implemented as a party in this writ appeal. my lord.
No. The simple reason is your only prayer is required that you and another party has been considered and found to be technically responsive, and accordingly you are there, right?
My lord.
Now, being the qualified bidders, right?
My lord.
But the petitioner did not when this filed this writ petition, you have not been made a party and obtain a stay order.
My lord.
A simple order could have been passed in the writ appeal is that you be implicate yourself, and then the writ petition should be taken up for consideration. Why this appeal should be pending?
My lord, this is the reason, my lord. As per the last, this matter, writ appeal was listed on 21st.
That will be the ground for disposal of the writ appeal. The only ground for disposal of the writ appeal will be that this order has been passed without making you a party. So you should pray before the writ appellate court that you should be allowed to party and dispose of the appeal, allowing the party and to hear the writ petition and dispose of. That's all. That should happen. That appeal is also pending. This writ petition will open. Now nothing will be benefited. Nobody will be benefited.
My lord.
You should have made that prayer before the appellate authority, or you should have made it for the writ appellate court.
The Honorable Division Bench, my lord, at last date of hearing has inquired us whether we have filed this implement application or not.
See, that is the only ground for a writ appeal.
My lord.
Without hearing you, that has been filed, you have not made a party.
My lord.
That writ appeal single online, it could have been disposed of.
My lord.
You should have made that prayer before the appellate court. Unless you made that prayer, why the appellate court will pass that order of its own?
My lord.
It is for you. Now what will happen? We'll be issuing notice. It will take another 1 month or 1.5 months.
My lord.
And the writ appeal is also pending. If the writ appeal is pending, this particular application will not be taken up for consideration. Thereafter, only when the appeal will be disposed of, this appeal for your implement will be considered. Then only the writ petition will be considered. You see the consequences.
My lord, the writ appeal was being dismissed at last date of hearing. But the Honorable Judge had asked us to file an application before the single bench, and on Friday, 9th of May, writ appeal is going to be taken over by the division bench, my lord. On very same day, I am hopeful that the same will be disposed of, my lord.
What was the last order passed? What was the last order passed in the appeal?
I just request my learned colleague to hand over the last order.
What is the last order passed?
In IA number 91,
In the IA number 91 is before this court or before the division bench?
division bench,
For division bench.
it is clearly mentioned that there should be implement by the applicant to file before this court.
Yes, that's right. Then what is your prayer in the appeal?
Our prayer in the appeal is, my lord, for the stay of the order dated 17th of March. Let me read, my lord. The interim order dated 17 in 2025 passed by the learned single bench.
See, once you are implemented here. Once you are implemented here, the case will change, the nature of the case will change. Anyway, up to you. What's your good name?
Abhijit Kumar Pandey, my lord.
Heard Mr. A.K. Pandey, counsel appearing for the petitioner, for the applicant. And Mr. M. Kato, learned Deputy Solicitor General of India, for the opposite party numbers 2 and 3. By this application, the applicant submitted that along with another bidder has been found to be technically qualified bidders for Namchik, NAMCHIK, West coal mine for sale of coal in the state of Arunachal Pradesh. The opposite party number 1 filed the connected writ petition WPC number 109 AP 2025, being aggrieved with its disqualification in technical bids for the said Namchik East coal mine. But in the said writ petition, WPC number such and such, and the respondent number, opposite party number 1/writ petitioner, did not make the applicant, comma, a necessary party for adjudication, though a necessary party for adjudication of the said writ petition preferred by the opposite party number 1. Hence, this application for implement of the applicant in said WPC number such and such. Mr. Pandey, counsel appearing for the petitioner, also submitted that there is an interim order that the court, while issuing notice in said connected WPC number such and such, first an interim order on 17/03/2025 directing the respondents herein not to finalize the tender process without the leave of the court, which is still in force. Issue notice returnable by 4 weeks. As Mr. M. Kato, DYSGI, appearing for the opposite parties number 2 and 3, accept notice, no formal notice. Applicant shall file requisite extra copies to Mr. Kato by tomorrow, obtaining necessary acknowledgement from him that regard. Applicant shall take steps for sufficient notice on the opposite party number 1, register post OTD, providing its correct info for address by tomorrow. In addition to petitioner, applicant is also allowed to take steps just to service security. Thereafter, let's start.
My lord, oblige, my
Oblige. Your good name?
Yes, Your
Your good name.
P. Vankan.
Okay, counsel for the petition. And Mr. M. Kato, DYSGI, for the respondent numbers.
One. Respondent number one.
One. Who is for 2 and 3?
Well, they are the private respondent.
No representation on behalf of the respondent numbers 2 and 3. The name of the councils have been reflected in the cause list. Where was the office number? That is 05052025. Await service reports on the respondent numbers 4 to 8. List on. Twenty-sixth of May.
Number 25.
Madam, here I'm photo Malad.
For respondent. And it seems that the counsel for the petitioner is a Guwahati-based lawyer. Today he is not present. We have already filed our affidavit and record was also called for.
No representation on behalf of the petitioner on call. The name of the 3 councils have been reflected in the cause list. Notice in this case was issued on 22/02/2024. The respondents in the Union of India, number 1 to 4, have filed its affidavit on 30/04/2024. Was serving a copy of the same on the counsel for the petitioner. However, the petitioner has not filed any such rejoinder to the affidavit of the respondent numbers 1 to 4. Issue rule. As the respondents have already appeared and filed their affidavit, no formal notice need to be issued to those respondents. Mr. Kato, learned deputy SCI, appearing for the respondent numbers 1 to 4. On all fairness submitted that the councils representing the petitioners are outstation councils, i.e. from Guwahati, and requested and prayed before the court to place this matter for hearing on any other date. Okay. List on. Twenty-seventh of May. Registry shall communicate, inform the counsel for the petitioners about the next date of hearing of the case, of this case, to them in their respective mobile numbers given in their filing form, and shall submit a report in that regard.